Hello, my name is Jacob Lixton, and I'll be explaining the process of voir dire and its significance in a criminal trial. So, explain the legal term voir dire, its origins, and its purposes. Voir dire is a process by which jurors are questioned about potential biases in their background and whether they are suitable to sit on a jury. This process is conducted by a judge and attorneys where they select jurors to hear a case. It is by that same process that expert witnesses are questioned about their qualifications and backgrounds on a subject before allowing them to give testimony during the trial. Detail the process of voir dire and distinguish between preemptory and discretionary strikes of potential juror members. A jury is selected by the process known as voir dire, in which the judge and attorneys are present. The attorneys will then question the jurors about their background and any biases they may affect the trial going forward. Both counsels use preemptory strikes to remove potential jurors who are believed not to be fair and impartial. Provide an opinion on whether or not the process of voir dire serves its stated ends. I believe that in most instances, voir dire is effective and used the way it was intended. However, I also think that attorneys manipulate the process and select jurors on whoever gives them the best odds at winning the trial. Create improvements in the current system of voir dire to ensure fair and impartial jurors for criminal trials. I believe an improvement that can be implemented can be made prior to voir dire, and that is by having a process of selecting jurors not done by the same district, but by others as well. This may decrease impartiality and the potential of knowing the case. Explain whether or not a defendant is entitled to a fair or a perfect jury. The U.S. Constitution was established to provide America with a government and fundamental laws while guaranteeing that every citizen is provided basic rights. Within that U.S. Constitution is the Bill of Rights that presents the first 10 amendments, one of which is the Sixth Amendment, which gives the accused the right to a speedy and public trial by an impartial jury. Distinguish between preemptory strikes of jurors versus strikes for cause of potential jurors. Preemptory challenges are limited and are reserved for attorneys to reject a certain number of potential jurors without cause or reason. Strikes for cause is a method by which attorneys remove jurors from a jury panel. There is no limit to the number of strikes for cause, and attorneys must state a reason for removal.